Good to see you both. And we only have one case on the docket this morning to be argued virtually, and that is State versus Oliver. And you both have argued before us many times, but I just like to go over the ground rules, and especially since we're, recording this, and also it's going Facebook Live. So each of you will have 15 minutes to present your arguments, and obviously the appellant may reserve up to 5 minutes for rebuttal. We do not use the names of victims, nor do we use the name of children. Either we just refer to them as a victim or as a child or by initials or something, but preferably not even the first name, but just, in some generic capacity. And you both can hear me. That's one reason why I like to talk to you, so I can see in advance whether you can hear or not, and we can all hear you. So without further ado, then Mr. Kuchief, you have 15 minutes and you may reserve up to 5 minutes.
Thank you, Your Honor. Your Honors, may it please the court, counsel, I will reserve 3 minutes.
Okay, thank you.
I know I'm going to need more than that for Attorney Corrigan. So, what's the difference between rape and sexual battery? Is that a riddle? It's not a riddle, or could it be in this case? This is an important case. So, let's talk about what is coercion, what is substantially impaired, two critical concepts. This case is not about an erroneous instruction, but what it is about, it's erroneous lesser included offense that the facts do not support. Now, this is a very interesting case here in many ways. An instruction regarding a lesser included offense should only be given where the evidence presented at trial. Okay, so let's talk about the evidence. Both reasonably support an acquittal of a crime charge and convict upon a lesser included offense. Did you notice the charges in this case? This is your garden variety, if you will, if we can speak, as cold blue steel lawyers. Rape, party, things go bad, and then the woman says, well, this happened, it's rape. It's not, an abduction and something out in a dark alley. So we're at a party, a person accused Anthony, I'll call that person Sarah, who has a boyfriend, feeling good, relaxed, loosens up. She's charged with, charges Anthony with 4 counts of rape, 3 kidnapping and abduction charges, 2 guns, throw in a misdemeanor. So the testimony of force, not consent, but no rape, did not happen, the jury says. So in the state's narrative, very nicely put narrative account, in their second sentence, the state says, Sarah was probed by a sexual assault nurse examiner because Sarah said she was raped. So, but the jury didn't buy it because the state's case simply does not add up here. So how do we get to sexual battery, which is what this case is all about? There's a unique opportunity, Your Honors, for you to look at this and really expand or refine the definition. So being drunk, here's the facts. We're having a party. It's a group of young adults. I think 7 or so of them, typical party, dancing, patting on the butts, twerking, drinking, having fun, no drugs. So throughout the course, they're having a party and the girls go upstairs and Sarah and Anthony stay downstairs. There's another person on the couch down there with them. So the state says, and Sarah says, Anthony grabs her from the chair, force, pulls her into the bathroom, force, locks the door. By the way, the testimony on the lock was that it was broken from the homeowner. So then we have forceful anal and forceful vaginal rape. Force, force, force. So there's no evidence of resistance. Well, there's no evidence of screaming noise. No one heard any noise, anything like that. Then she says, well, she has a boyfriend, even though she told Anthony she does not. She's afraid of getting home late. Force for the jury says no rape, despite all this force. Now, how can this be? And what does it mean? Drunk. Okay, drunk or intox is not the issue, Your Honors. This is of critical importance. So when we're talking about sexual battery or even rape, let's talk about drunk. Now, substantial impairment. Anthony must know that Sarah's ability to apprise the nature of the sexual encounter was substantially impaired. The record does not support this in any way. Now, if you look at the trial transcript, the trial prosecutor says, calls this rape by intoxication. No, no, no. Let's talk about the evidence. So here we have the same nurse, and the same nurse, the medical examiner says Sarah is alert, oriented, careful. Nothing about intoxication coming from the medical exam. The detective, how many detectives have we heard? Does not, quote, does not appear to be under the influence. This is a policeman talking. We've seen hundreds of reports where it's easy for the police officer to say, oh, look, she was suffering from intox. Sarah herself never said she was impaired. Think about it. Never said she was impaired, let alone she never said she was drunk. Now, I've been to parties before. I gotta admit, I've gotten drunk before, but I've also been to parties where I would drink alcohol, may have had a fair bit to drink without being impaired, let alone, don't forget, substantially impaired. And this party was over 6-7 hours. So this court has agreed every alcohol consumption does not lead to substantial impairment. And State v. Bowden on my brief, page 23. So the jury didn't believe Sarah. It's interesting, no rape conviction on anal sex at all. So the jury did not believe force. Otherwise, it would be rape. So, and by the way, Heather, her friend, said when she asked Sarah if she was raped, Sarah said no. And then again, we have the lying about the girlfriend and the boyfriend, that Sarah was a girlfriend and had a boyfriend waiting. So remember, substantial impairment, there's no evidence of that. So, and I challenge the government here to demonstrate for you the evidence that will support substantial impairment. So how do we get to coercion now? So coercion, you know what coercion?
Counsel, before you get to coercion, let me just ask a couple questions. When she was interviewed by the detective and she went to the hospital and the same nurse interviewed her, do we have an actual time frame? I think the state says it was several hours later. Was there an actual time frame that was presented?
I'm not aware that there's sufficient evidence to demonstrate a timeline. If you look at the course of events, we have chit-chatting with the girls upstairs and lamenting about what happened, and then saying we want to go to the hospital, and then she did go to the hospital. So that seems to be a quicker time frame than 3 or 4 hours. So the timing of when the officer did interview her, yes, it's unclear, Your Honor, but in my estimate, it was sooner than later. But what doesn't matter, and does he ask the victim, claimed victim here? So the reason coercion is important here, the record is so full of evidence of force, so the jury can't really, under these facts, acquit Anthony of rape. How can this be? So force, and then acquittal of rape. So what's the difference here? If this case is enforced, then how do we get to a coercion in this case? So coercion is when I talk my way into it, or when a person talks their way into it, or tries to give, come on, now can't you, come on, I took you to dinner, come on, you need to put out here. Or look, we've done it before, we can do it again. That's coercion. So you can't put your coercion in this case, equating it to force. Sexual battery, look at the definition. It says person coerces the other person to submit by any means that would prevent resistance by a person of ordinary resolution. There's no evidence of this. There's no evidence that Anthony did something that would prevent resistance. The testimony is that Sarah did resist. She said no, but was forced. So the second of sexual battery, we're back to substantially impaired. the offender knows a person's ability to apprise the situation of having sex here in this case is substantially impaired. So if we just agree for the moment, arguendo, that Sarah was not substantially impaired, then we therefore must, so you have to acquit Anthony of rape, which I don't see how that can possibly be in this case, and then secondly, find him guilty of sexual battery. So we have to get coerce equals force. Now, how can that, what's the difference between the two? It doesn't make sense. So when we equate the two, so when we say, how can there be acquittal on rape because there was a lesser included offense where there should not ever have been, that's what happened here. So we have Anthony found not guilty of rape, and then, oh, well, you know, there's a substantive lesser included, you know, no. In this case, it was error to give that charge. Now, if we don't have rape and we have error on lesser included, we can't have kidnapping. So when we look at kidnapping, we look at the factual basis here, but let's talk about ineffective assistance for a minute. So we don't have a lawyer arguing, well, released in a safe place. We don't have that. We don't have a lawyer arguing Rule 29 with some foundation so that we can look at it here today. And what about this gun? Let's talk about this gun for a second. Why does a lawyer, when you say, oh, well, you're going to tell me, well, it's trial strategy that the lawyer said, well, he had a gun. Why? How's that trial strategy? What it is ineffective assistance. And secondary to that, here's an easy one for you today, Your Honors. The gun wasn't loaded. There's no proof the gun was loaded. How do we get a felony conviction of that? So what happened here is, I'm not going to get into manifest weight sufficiency. We all know the standard of that. What happened here is the jury lost its way. The state did a great job in presenting this case. But what happened in the breakdown when we get to a lesser included offense? So the state simply didn't present sufficient evidence. There were too many mistakes here, and it was simply unfair to give her a lesser included offense. The last thing is significantly weakened. Giving the charge of significantly weakened, that's not what the standard is here. Substantial impairment is not the same as significantly weakened. You know, the General Assembly would have said significantly weakened, but it didn't. I can be significantly weakened from writing this brief, okay? But that doesn't make me substantially impaired. So if there are no further questions, I won't continue because I know I'm running out of time here. And thank you, Your Honors, for this ability here today.
Thank you. Thank you. Attorney Corrigan?
Yes, Your Honor, thank you. May it please the court, and good morning. I'm Jacqueline Corrigan on behalf of the state asking this court to affirm Mr. Oliver's convictions. As it was framed in Mr. Oliver's brief, Mr. Oliver, in a nutshell, is claiming that there were three general problems with his trial and conviction that he believes should overturn his conviction. As framed, one of those is the jury instructions, but as we're going to demonstrate, the trial court did not plainly commit error, not as to the law and not as to the facts. Concerning Mr. Oliver also believes that the evidence was a problem too, but it was sufficient to support the convictions and his convictions were not against the manifest way of the evidence. And finally, concerning his counsel's performance was not prejudicially defective in this case. Concerning the jury instructions, obviously the state's contention is that the trial court did not commit plain error. Concerning coercion and the definition of sexual battery, it is not this court's duty to do as counsel has invited this court to do today, to redefine an offense that the General Assembly has actually defined. And so we have coercion. There is no legal mystery to that. It includes control or domination by a person by something less than actual force, which means less than a threat of violence or violence itself. It is not persuasion. It is repeat, and it can include a repeated, ignored, ignoring a victim's statements of no, and a victim's struggles. This court has already reached that in State versus Pyatt. So resistance, screaming is not required to prove either rape or sexual battery or any other sexual assault, nor is sobriety on the part of the victim required, nor is behaving like a nun required of the victim. So dancing, being at a party, drinking, none of these things precludes a sexual assault, and none of these things indicates a person's consent to having sexual relations with somebody. The facts of this case that were in front of the court when it permitted the sexual battery lesser included jury instruction was that the victim in this case repeatedly told Mr. Oliver no. She struggled against him while he committed his acts against her and laughed at her when she said that he was hurting her. Okay. So these facts were sufficient for the jury to show coercion. Let's also look at some of the other things that Mr. Oliver did. He dragged her into a tiny half bathroom where she had no room to get past him, no room to get away. He acts like he locks the door. Whether she knows that the door is capable of actually being locked is immaterial. He acts like he locks the door. He blocks her from the door, and physically manipulates her in that bathroom. Again,
But counsel, when you're saying all this stuff, that sounds an awful lot like force.
It does.
And I guess that's the reason why he was indicted for rape.
That's why he was indicted for rape. But if the jury didn't believe that it was to the level of force or use of force, then they could find that there was coercion, because that's one of the reasons why sexual battery is a lesser included offense to rape, because instead of the purposefully mens rea, you've got knowingly. Instead of force, you've got coercion. So if a jury can't find that there was force, then the jury can find that there was nevertheless coercion. But they're not the same thing, and so that's why the legislature has defined it the way they have. And then so we have, that was not an error. And I would remind the court, because we are talking about jury instructions, ordinarily there has to be an abuse of discretion. That means that it has to be, under the Blakemore standard, which I didn't cite in the brief, but which is subsumed within the case that I did cite. It's got to be arbitrary. It's got to be unconscionable. It's got to be unreasonable. And layered on top of that, because trial counsel did not object to these instructions, this court has to find plain error. So you not only have to find an abuse of discretion on the part of the trial court, but it's got to also be an obvious error, and it also has to affect the outcome of the case. So, but for that, the verdict would have had to have been not guilty. But we don't have that. And so, on that basis, the state's contention is that there was no error in these jury instructions. But I would like to move on and discuss substantial impairment, because that affects the other count of sexual battery. And I would remind the court, before I start talking about substantial impairment, we have these two counts of sexual battery. The trial court decided when it imposed sentence that the sentences for each of these counts was to run concurrently. So even if this court were to find that maybe there was a problem with the substantial impairment, it's not going to affect the length of his sentence. But again,
well, it will affect obviously how many convictions he has, though.
That is true. But as a practical matter, he would still remain in prison for the same length of time. But the state's contention is that there is no problem with the substantial impairment either, because substantial impairment means a present reduction, diminution, or decrease in a victim's ability to control or appraise the nature of her conduct. And that's from State versus Zay. And that, you know, if you think about the substantial weakening or significantly weakened, that's essentially the same thing, which is what the 8th District also found, you know, when it looked at a similar question. You know, we don't have to have vomiting, staggering, passing out of the victim to have a substantial impairment in the victim's ability to appraise the, you know, the nature of her conduct. And yes, mere intoxication does not automatically mean that somebody's substantially impaired, but intoxication can result in substantial impairment. And in this case, we do have the victim testifying that she'd had a lot to drink and that she had not had a high alcohol tolerance. She'd been drinking for a course of about 6 hours. And other people around her, even HV, who was not the victim's friend, who was an acquaintance, didn't know the victim very well, testified that this victim, even though she wasn't sloppy drunk, she was very drunk. And she had to be followed, you know, other people testified she had to be followed upstairs to prevent her from stumbling on the stairs and falling. So this is a person who is indeed substantially impaired. So, you know, the jury then believed that this victim was substantially impaired enough to believe that she had been a victim of sexual battery. So that means that this court did not commit a plain error. Oh, and I would like, by the way, to Judge Carr, you had a question about the time frame.
Mm-hmm.
I have that for you. The offense occurred, according to the testimony, maybe 2 or 3 o'clock in the morning. The victim, who was told by HV, by the way, you know, if you were really raped, you should go to the hospital. Well, she went to the hospital and she arrived at Akron General Medical Center shortly before 4 o'clock in the morning. It's 3:58 a.m. according to the emergency room records. She is seen by the sane nurse at 4:19 in the morning. The sane nurse also records that she was evaluating the victim an hour later, so shortly before 5 o'clock in the morning. She is not spoken with by an Akron police officer until 7:36 a.m. So about 3.5 hours after she arrives at the emergency room. So that's I hope answers the question as to the time frame of how long it was between the offense and the time when sane nurse and the Akron police officer were able to observe her and to see her conduct. Which is
So the sane nurse actually would have evaluated her depending on whether the offense occurred at 2 or 3. And it would have been anywhere from as little as an hour and 19 minutes to as much as 2 hours and 19 minutes.
That's right, Your Honor. So that is a little bit of time for, you know, as we know through practical experience, that the jury could be expected to know that that's a little bit of time for at least some effects of alcohol to start to wear off with someone.
Nonetheless, it's within the DUI parameters for a breathalyzer.
It is indeed, Your Honor.
Okay, thank you.
So, and I know I only have a few minutes left, but again, the state is going to rise to accept the defense challenge to say how this evidence was, you know, there was sufficient evidence and that the convictions were not against the manifest weight of the evidence. Remember, for sufficiency, this court has to review the evidence in the light most favorable to the state to see whether the state met its burden of production, not persuasion, but production. For manifest weight, then the court looks at all the evidence and looks at it de novo, but has to be mindful that the jury, of course, is in the best position to assess the credibility of each of the witnesses, and that there is not going to be any error just because a jury chose to believe the state's version of events. So the jury has to have completely lost its way and really committed a manifest miscarriage of justice. And I would urge the court to look at the Apanovich factors that were cited in the brief, which, gives you factors to look at, in a cold-hearted sense, did the jury lose its way? But for sexual battery, which requires that he knowingly coerced the victim in this case to submit to sex by means that would prevent resistance, or had sex with her knowing that she was substantially impaired, again, he drags her into the tiny bathroom, acts like he's locking the door, she can't get away. That helps to show kidnapping. It also helps to show the coercion that was involved in this case. And we've already reviewed substantial impairment, that everybody testified that she was very drunk at the time. And I'd like to briefly touch upon the ineffective assistance of counsel assignment of error. The claims are that counsel did not argue for mitigation for the kidnapping charge, and as it was put in the brief, that she was released in a safe place unharmed. Frankly, this is specious. I've cited a case in the brief saying that a sexual assault, you release somebody after a sexual assault, they're not released unharmed. The sexual assault itself is the harm. So that's specious to say, this person was released unharmed. So that was a reasonable strategic choice not to make that argument. As far as conceding that Mr. Oliver had a gun, that too was a reasonable strategy, especially in light of the fact that we had 4 witnesses that testified individually that he had a gun they had concealed on his person and then waved it around at different points during the night. So that's a reasonable choice not to try to argue that he didn't have a gun. As far as proof that it wasn't unloaded, he has a prior conviction for escape, which is a violent offense. That means that that raises the concealed weapon charge to a felony.
And thank you, counsel. You're out of time now. Thank you.
Thank you very much.
Attorney Kudic, if you have 4 minutes, actually.
Oh, super. Thank you, Your Honor. I appreciate what Attorney Kurgan said regarding the time frame. I think that supports my position even further, because there's no evidence of impairment, certainly not from the hospital, from the police, or anybody else. No evidence. So it goes to my argument. And also, thank you, the state's version was indeed rape. That's the whole point of this. How do we get to sexual battery? And by the way, everybody did not testify that Sarah was drunk. That's not the evidence. Check it out. I read through that transcript, God knows how many times. And the reality is Sarah herself says she wasn't, and that's important. So nevertheless, I ask you, implore upon you to look at substantial impairment, what that translates into. The other thing about it, just as an aside, the gun, you need to prove, by the way, that a gun is loaded for a felony. Notwithstanding that, what happened here, the state did not rebut appellant's assertion of argument here. The state hasn't rebutted substantial impairment issues, nor the topic of coercion. I mean, demonstration of force was particularly argued by the state here, and I admire that because that's exactly what happened. So when you look at the issue of counsel didn't object, well, I think counsel did object, because when it got to the issue of lesser included, counsel did object to a felony lesser included, because he argued for a misdemeanor sexual imposition. So there was tacit objection to that, and I think that's important. The issue of sentencing right now is important, because I'm going to ask this court to remand it for trial. This case was so unfair, the manifest miscarriage of justice can be seen by many things, as I've identified in my brief. God bless the lawyer who has to argue against a sad case of a victim. None of us are going to condone the claim of Sarah here. However, when we look at Sarah, we see that she has certain motive to lie. And that also goes to manifest issues that I'm not going to discuss because it's pointed out clearly. The last thing is, when we talk about vomiting, stumbling, that's not what the standard is here. So it's important for this court, upon conclusion, to view the distinction. How do you get to sexual battery when the state cannot prove, and then the state does prove, and then the jury says that Sarah was not forcibly raped? How do we get to sexual battery? And the answer is that you can't, and the only way you got to it is because the court erroneously gave a lesser included offense jury instruction. I want to thank this court on behalf of my client. I am court appointed counsel, and thank you for hearing his case today in this very different forum that we're facing.
Well, thank you both for your arguments and your professionalism. We will take the matter under advisement, and we will issue a written opinion that will be sent to both sides, and we also release online. And so the next oral argument will be Thursday, May 20th, and that will be video argument, I should say. Okay, thank you so much, and everybody please enjoy the sunshine today as much as we can. All right. Thank you.
Your Honor.
Stay safe.
It's a pleasure to be here in front of you today.
Thank you.